Call to order. Can we start with the Pledge of Allegiance?
The microphone, please. Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And continue with roll call.
Yes. Board Member Cohen Thompson. Chair Lee,
Here.
Vice Chair Moreno,
Here.
and Board Member Bras.
Here.
And for the record, Board Member Russell and Stewart are both absent due to excused.
Yeah. Okay. And community forum. Do we have any members of the community wish to speak or ask questions? There's someone coming.
No, she's a staff. She's staff. There's no card turned in for community forum, and no one is online.
All right. And then so we'll proceed with the consent calendar approval of the last meeting's minutes.
So move.
Okay.
Got so moved.
Seconded.
Second.
Okay. And Board Member Peggy Thompson. Okay. Chair Lee.
Yes. Approve.
Okay. Vice Chair Moreno.
Yes.
And Board Member Ross.
Yes.
Okay.
Moving on to the community board secretary report. There's anything to report?
There's nothing to report tonight.
Okay.
Thank you.
And the city attorney's report?
Nothing to report, Chair.
Okay. And then no report from the chair. And actually, any comments, anything to report from the members of the committee?
The only thing I have is there's been some articles around Flock and how it's being used by external entities outside of California and how they shut it off from their end for California and a few other states. Also, ICE has been using some biometric data for people that they're apprehending or potentially apprehending. So just keeping that in mind as we are thinking about surveillance technology and how we currently, from my understanding, don't use biometric pieces, but we can keep that in mind for our board to investigate or keep on top of that.
If you have specific examples, go ahead and send them to me in email. I can send it to Flock representative.
Okay, I'll send you that, and then also the surveillance,
Sure.
biometric stuff that ICE is using. It's not Flock; it's a separate app. But I'll send that to you.
Send me the Flock related anyway.
Okay,
thanks.
My apologies. I skipped the report from the city council liaison. I don't see him.
I told him that this was going to be a training, so he's going to take a night off.
Okay. All right. Then now proceeding with the action calendar, which is training on the Brown Act, and then other relevant acts and roles. Attorney Reisner.
Good evening, Chair Lee and board members. This is a training evening tonight. Some of you have heard this before, but there are some of you who are new who have not. So we're going to go through all of the material. It's fairly long, as you can see by the slide decks that are in front of you. Some of it is more relevant to you than other parts of it. The stuff that's not as relevant, I'll go through a little quicker than the stuff that I think is more important. We're going to talk about open meetings, public records, conflicts of interest, the powers and duties of the board, the code of ethics and conduct. And I'll do my best to get through it all this evening. If we don't, for some reason, we may have to come back and finish up at a subsequent meeting. I want to ensure that each of you have a chance to ask questions as well. So please feel free at any time during the presentation to stop me if you have a question and ask, and I'll do my best to answer that for you. Of course, if you have questions afterward that you think of later, you're free to email me or telephone me, and I'll be happy to address them then. You're going to find that the law for public agencies about meetings, documents, and conflicts of interest can be really complicated. There's a lot of law, there's a lot of case law, just a lot of things going on. The law, especially surrounding the Public Records Act, can also be, or feel at least, somewhat intrusive sometimes. We'll talk about that in a lot more tonight, but let's start with the Ralph M. Brown Act, which is about open meetings. And I guess I'm switching slides tonight. Where do I point it?
This one.
Oh, this one's not working.
Let me just put it on the stand.
Well, I can't get it close enough is the problem, I think, as well. Okay. I'm good, Naveed. So we're going to start with the Brown Act. This is state legislation that was enacted in 1953. It's named after Assemblyman Ralph M. Brown. Let's go to the next slide so you can. There we go. And this is Ralph himself. The act was passed in response to a series of articles that were in the San Francisco Chronicle that were called Your Secret Government. Those stories revealed that secret meetings among government agencies were very common. And while the biggest culprit called out in the article were special districts, there were other non-city agencies, as well as city councils who were holding special meetings, special secret meetings that the public wasn't aware of. There were also times where city councils or other governing boards of agencies would kick members of the public out of meetings. Sometimes officials would publicly vote one way, and then they'd meet in secret later and vote a different way. Since 1953, the Brown Act has evolved significantly because of a series of court decisions, amendments that the state adopted, but the central rule hasn't changed since its passage. Oops, wrong way. So I want to read to you the preamble of the act that I think is important. It gives you the essence, or the point rather, of what the act is all about. The people of this state do not yield their sovereignty to the agencies which serve them. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments they have created. That's the very beginning of the Brown Act. So the basic principles are transparency, which is essential to any type of democracy. And you'll see here also, this is at the very beginning of the Brown Act. All meetings of the legislative body of a local agency, that's you, shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency, except as otherwise provided in this chapter. So there are exceptions. We'll talk about that a little bit. And that will not apply to you as much. So these are the things that we're going to talk about. Who does the act apply to? What is a meeting, which is more complicated than it sounds? What rules apply to meetings? Requirements of agendas? And what are the remedies for a violation of the act? Oh, thanks, Naveed. So these are the things that we'll be talking about in a little bit more detail. So let's go to the next slide, please. Who is subject to the Brown Act? Next slide. Legislative bodies are subject to the Brown Act, but what's a legislative body? So obviously it's a city council. They adopt and approve legislation all the time, but the name is a little bit misleading. Legislative body can also be a body such as you, that does not approve or adopt legislation. So it includes the term legislative bodies includes any body that has decision-making authority, whether elected or appointed. Again, of course, that includes the city council, but it also includes subordinate bodies such as boards, commissions like yours, committees and task forces, whether advisory or decision-making, created by formal action of the governing body. So you're an advisory board. So for purposes of the Brown Act, you are a legislative body. The act also applies to standing committees of less than a quorum of the legislative body that have a continuing subject matter jurisdiction or a regular meeting schedule. Examples include budget committees, employee relations committees, things like that. The act typically does not apply to ad hoc committees, and we've had an ad hoc committee here once or twice. These are committees that are comprised of less than a quorum, and they're usually created to deal with a single issue, and they dissolve after their work is done. If you created an ad hoc committee that did not dissolve at some point and that started dealing with more than one issue, that would become then a standing committee automatically and become subject to the Brown Act. Next slide, please. Yeah. And what is a meeting? So let's take a look at that. Let's go to the next slide. There are 4 elements to a meeting. Government Code Section 54953 puts forth these 4 things that are required to have a meeting. A congregation of a majority of a legislative body at the same time and place to hear, discuss, deliberate, or take action on an item that's within the subject matter jurisdiction of the legislative body. So a meeting is any gathering of a majority of the members to hear or discuss any item of city business. In earlier versions of the Brown Act, officials could discuss matters as a group outside a public meeting as long as they didn't make a decision. That's now illegal. So if you discuss anything that's within your subject matter jurisdiction as a group, a majority of you, that's a violation of the Brown Act if it's done outside of a noticed public meeting. Next slide. Go ahead, Manny. So just through a little humor here. Next slide. Individual contacts, those are not meetings. So individual contacts between less than a quorum, as long as you avoid creating a serial meeting, which I'll talk about in a second, with other members. So you can have contact with each other in social settings. You can have individual contact with each other to talk about the weather. You can have individual contact with each other. You could even talk about things that relate to the subject matter jurisdiction of the board, except I would advise against that for what I'm going to talk about in just a second. Go ahead to the next slide, Manny. A majority of you can attend conferences and seminars. That's okay. But the conference has to be open to the public and limited to issues of general interest to the public and cities. And you can't discuss any business of the Surveillance Advisory Board at that conference and seminar. Next slide, community meetings. Community meetings such as town halls, Chamber of Commerce luncheons, other community lunches are not typically meetings, but they have to be, again, open to the public and publicized in some way. For example, homeowners association meetings are usually not open and not publicized, so they would not qualify. My advice when you're attending a community meeting is to avoid any direct participation. It's okay to say, this has been interesting. Thank you very much for the punch and cookies, but not, I will vote against Mr. Smith's development project. Or in your case, I'll vote against, using that surveillance equipment, or I'll vote to use that surveillance equipment. Wouldn't recommend doing that at any meeting. Next slide. Again, a majority of you can attend and participate in social or ceremonial events as long as you don't discuss any of your business. Next slide. Other exceptions. Members of a legislative body can attend the meetings of other legislative bodies, but you must still avoid discussing items of city business other than as part of the scheduled meeting. So you could go to a city council meeting, for example, and talk about your business if it was on their agenda. You could go to a city council meeting and talk about your business as part of community forum. That's okay as well. Meetings of ad hoc committees are also not subject to the act. I mentioned that earlier. But you want to still be careful, right? Finally, members of a legislative body who are not members of a standing committee can attend a meeting of the standing committee. Hopefully, we're not going to have any of those because they create their own headaches. But if we did, and they held a meeting that's noticed, it would have to be noticed again, like one of your meetings. You could attend as a member of the public and observe it. You could not participate in it. Next slide. Illegal meetings, let's talk about those. Illegal meetings, of course, are meetings that are conducted in contravention of the Brown Act. No exception permits a majority of a legislative body to meet with staff in advance of a meeting for a collective meeting. We'll talk about that in a second. Team building sessions, retreats, workshops, all have to be noticed. Next slide, please. Serial meetings are illegal. And what are those? Well, it's a series of communications of any kind, direct or indirect, where indirect could possibly include intermediaries or technological devices, by a majority of members to discuss, deliberate, or take action on any item of business or potential business. So this is where we can get into trouble. So let's say that Board Member Smith calls up Board Member Jones and says, we're going to talk about that contract with Flock to buy more cameras. And I really don't like that. And I think we should vote against it. And Board Member Jones says, yeah, you're right. I'm going to vote against that. They hang up. Board Member Jones hangs up, calls Board Member Harris. You know what? I just talked with Board Member Smith and we decided we're going to vote against that. And we hope you do too. Hangs up. They call another board member. That's called a daisy chain. So you go from 1 to 1 to 1 to 1. Once you get to 4, you're done. That's illegal. And it can happen with staff as well. So if staff holds a one-on-one meeting with you and you disclose to us how you're going to vote on a particular issue, and we go to 3 other board members and disclose that, we've now conducted a serial meeting. We won't do that because we know better and we haven't done it. And it's okay for us to have one-on-one meetings with you to brief you about things, which we do frequently with the city council. In fact, we hold weekly meetings with each of the members of the city council to brief them about what's going on, but we never discuss what one council member said about a particular issue. So we could do that same thing with you. Let's go to the next slide. Kind of got ahead of myself here. Staff briefings are okay again, as long as they're informational and we don't share the views of other members. Let's go to the next slide. So you can't meet as a majority of the legislative body with staff in advance of a meeting for a collective briefing. So I can't hold a meeting with the 4 of you, for example, to talk about what we're going to talk about. Can't do that. Collective briefing is, again, that's a serial meeting, results in the discussion, deliberation of things that are within your subject matter jurisdiction. Again, not okay. Next slide. So every meeting has to have an agenda. An agenda has to do 2 things. It has to be effective notice. In other words, it has to talk about what time the meeting is going to be held, where it's going to be held, who the body is that's holding the meeting. It also has to adequately describe the items to be considered. So there has to be enough information there so that the public would know or have an idea of what you're going to talk about. Next slide. 4 different types of meetings. 2 of them will apply to you, the other 2 not so much. They potentially could, but not likely. There's regular meetings, special meetings, adjourned meetings, and emergency meetings. And the type of notice can be different depending on the type of meeting. Regular meetings, which are meetings that you're typically going to have. For a regular meeting, the public has to be given an opportunity to address the legislative body on any item that's on the agenda, including closed session items, although they can't participate in closed session, and we're going to talk about that in a bit. And any non-agendized item that is within the subject matter jurisdiction of the legislative body. So if any of you have followed city council, you may notice that at most of the city council meetings and also at your meetings, we have community forum. That's the place where some member of the public can come to you and talk about things that aren't on the agenda that evening. You can't take action on those things, but you can hear what the person has to say, and you can direct staff at that point to bring it to you on a later agenda if you so desire. The location of the meeting also has to be somewhere the public can get to. So it has to be freely accessible. We can't come in here and lock the doors after we've posted an agenda and not let people in, right? That wouldn't work. Next slide. A special meeting. Typically, special meetings are called by the presiding officer or a majority, or in this case, the municipal code allows staff to call a special meeting. Agendas have to be posted 24 hours in advance for special meetings. We have to provide written notice to members, to you, and the press if they've requested it. And the discussion has to be limited to agenda items. We cannot have a community forum and hear discussions from members of the public about items that aren't on the special meeting agenda. Let's go to the next slide, please. Adjourn meetings, every once in a while we run into this. So let's say that we notice a regular meeting and only 3 of you show up. The meeting can be adjourned, but it has to be adjourned to a date certain. And then the notice of the adjournment has to be posted on the door of the chamber where the meeting is to take place. So in other words, let's say that you 3 showed up tonight for a meeting, and that was it. Nobody else showed up. There's only 3 of you. Chair Lee could then move to adjourn the meeting to a date certain in the future, say 5 days from now. What would that be? Let's say the 30th, June 30th. We would then have to post notice on the door, and we also post notice online so that the public knows. We don't do that very often because honestly, it's just easier to notice a new meeting than to have to post a notice on the door and do all of that kind of thing. So that's typically what we do, but I have seen it used twice here, but they were things that had to deal with the city council deliberating on the budget. Let's go to the next slide. Emergency meetings, you'll never have one. I can tell you right now, you just won't. I've been doing this for a little over 30 years, and I've only seen one time where there was an emergency meeting held by a governing body. That was the city council in Guadalupe after an earthquake. So an emergency meeting can take place if there's severe impairment, there's a dire emergency, and they can be done with 1 hour's notice. We also have to notify the press at the same time, an hour before the meeting. If the phones are out, someone has to go where the press is and tell them. The press has to be notified again an hour in advance. Dire emergencies like mass destruction, terrorist acts, or threat of imminent terrorism are reasons to do this. In either case, the body can meet in closed session, but only if 2/3 of the body vote to do that. So again, very rare circumstances. So just remember, when we're talking about things, don't discuss or make any decisions on items that aren't on the posted agenda. You can direct us, staff, to agendize things for the future if you'd like to. If, for example, if a member of the public brings something up that you're interested in talking about and it's within your subject matter jurisdiction, you can direct us to, or ask us to bring it back to you. Next slide. You can, when a member of the public brings something up in open forum, you can give a brief response to the comments. You can ask questions seeking clarification on an issue from us, from staff. You can make brief announcements, reports, and activities of members. You can make requests for future agenda items. You can direct staff to place an item on a future agenda. Those are the things that you can do without having them be on the agenda. Adding items to the agenda. So there is a process in the Brown Act to add items on the agenda, the agenda in certain circumstances. So if we post an agenda and we've missed putting something on that's important for you to hear, there are ways to deal with that. I don't like doing it because it deprives the public of notice, of effective notice, in my opinion. But sometimes it's necessary, especially if there's some impending deadline that's going to create huge problems if we don't hear an item. So here are the things that have to happen in order for you to do that. The item came to the attention of the agency after the agenda was posted. It requires action before the next meeting. So it can't be added just because it's expedient, right? There has to be a very good reason for it. And finally, the legislative body must expressly make the foregoing findings that we found out about it after the agenda was posted and that it requires action before the next meeting. So you'd have to make that finding, and it would require 2/3 vote in order to add it to the agenda. If any of you ever ask for us to do that, I'm probably going to discourage you from doing it and try to find another way to get it on an agenda so that you can hear it. The Brown Act requires that the public be allowed to comment at meetings. This is because the focus of the act is on promoting the marketplace of ideas by involving the public in the governmental process. So the Brown Act prohibits local government from banning public criticism of its policies, procedures, or officials. So if some member of the public comes in here and starts complaining about Chairman Lee, they can do that. Also, other provisions of state law make statements made at public meetings absolutely privileged, which means, of course, it's difficult to sue someone for libel who comes to a public meeting and criticizes a member of a body.
To the chair,
Yes.
regarding that, the criticism of individuals, a year or so ago when we were having, well, on school boards, I don't know about, again, some city council meetings, when they were having those disturbances, wasn't there something that came out that you could remove the people from the room?
You can do that if it is actually disruptive to the meeting.
Okay.
So if it prevents the body itself from moving forward with its business, yes, that can be done. But that occurs in very rare circumstances. And if you do that, there is a risk that the person or group that's removed can file a lawsuit. And there are a lot of cases where people have been removed for that reason and they've won later on, right? So this all relates back to the First Amendment to the U.S. Constitution, which is a very, very strong and important right that the courts do not like to overturn, all right? They want people to be able to exercise those rights.
So it has to be determined disruptive.
Yes, and so if somebody came into a council meeting beating on drums and being very loud and no one could hear themselves, then they could be removed for that. If somebody comes into a meeting and they're breaking laws, they're assaulting people, things like that, they can be removed for that. If they're coming in and just speaking and they're saying something offensive, probably not, because they have a right to be offensive, right? We did remove we did remove a person from a council meeting a while back, and he did say a lot of offensive things, but he was removed because he wouldn't stop talking when his time was up, and you can do that. So the public comments are time limited. Once that time is up, you can remove a speaker after that. You're welcome. Let's go to the next slide, please. So members of the public can't be required to register. For example, they don't have to sign in at the door. You can request that they fill out speaker cards, but if they don't want to, you can't make them do it, and you still have to allow them to speak. You can also adopt reasonable rules of decorum, such as time limits. That's okay. You can preclude speakers from disrupting, disturbing, or impeding orderly conduct of the meetings, which is what we just talked about. But if someone tries to say that somebody's speech is disruptive, that's probably not going to fly. All right. If somebody says something offensive and, the board or the council says, I really don't like that, we're gonna remove this person, that's just asking for trouble. Better to let them say what they're going to say, cut them off when their 3 minutes is up, and move on. You also have to allow members of the public to record the meeting. They're allowed to do that. They can come in with tape recorders, which people don't use so much anymore, but they can use their phone to tape, to record you, video record you, or audio record you. Go to the next slide, please. Closed sessions. We've never done one with the SAB since it started, but it is certainly possible, potentially. Closed session meetings typically relate to personnel matters, real property transactions, and litigation. Those are the three big ones. And the Brown Act allows for that. So in order to do that, you have to post a closed session agenda that generally discusses what you're going to talk about. And there's safe harbor language that's published in the Brown Act itself that you need to use to describe what that closed session matter is about. And the whole point of closed session is to allow the body to be able to discuss things that are very sensitive, that could actually harm the agency itself if it was discussed in public. For example, we always talk about litigation strategy in closed session. And I think you can probably obviously see that if we talked about what our strategy was in public, that the other side, who was either suing us or we were suing, would have our strategy in advance and be able to plan. So in litigation, you don't like for the other side to have your strategy or to know what your strategy is or to know what your next move is, because it can have a detrimental effect or impact on the course of that litigation. With personnel labor issues, employees have certain property rights in their jobs and they have privacy rights. And that's why we always talk about those in closed session, because to talk about them in open session would violate those rights and subject the city to potential liability for that. Real property, kind of the same thing as litigation. You want to talk about your strategy for buying a piece of real property, and you don't want necessarily the public to know about that until after the transaction's completed. So in other words, if we were going to talk about what we were willing to pay for a piece of real property, we don't want that out in the public, because then the person we're trying to buy the property from would find out what that is, and then they would be able to have an advantage over us we won't want them to have. Again, probably not something that you'll ever have to deal with, but good to know anyway, just to have an idea of what the exceptions are for closed session. So what are the consequences if we violate the Brown Act? first, before anyone can sue us for a Brown Act violation, they have to give the legislative body notice of of the violation, whatever that is, and an opportunity to cure the violation. So you may have heard people talk about cure letters. So if a member of the public thinks that we've violated the Brown Act, typically what would happen is we'll get a letter, and it's usually a member of the press. We'd get a letter saying, "Oh, so sorry. That's my wife, and I forgot to turn off the phone." Funny, it was on silent. So they'll send this letter describing what they think the violation was, and then we'll evaluate that and make a determination as to whether we think that's accurate or not. If we do think that there was a violation, what do we have to do to fix it? It's really pretty simple. You just have to hold another meeting on the same item. And if there was a vote taken that was in violation of the Brown Act, you just re-vote again and make sure that you don't violate the Brown Act that time, and that's cured. And then there's nothing anyone can do. There's a very short statute of limitations on the Brown Act. They have to provide their cure letter within 90 days, and then we have 30 days to actually do the cure. If they don't do the cure letter within 90 days, the right to complain about it's gone forever.
To the chair, so during
Yes.
that 3 days that we would have to cure it?
We'd have 30 days.
Oh, we have 30 days.
Correct.
Oh, okay.
Yeah, so they have 90 days to send us the letter.
Okay. Say the turnaround time to set up. a
Right.
meeting and to
You wouldn't be able to
notice,
do
right,
it in 3
okay.
days. Yeah, so you have 30 days to cure.
Question, what's the starting point of the 90 days?
When the alleged violation supposedly occurred. So it's always at a meeting, right? So if they're alleging that we talked or we took action on a matter that's not on the agenda at a meeting, there's a date for that meeting. So it would be that date plus 90.
So it's not enforcement of meetings that people don't know took place.
If we have a secret meeting, if something, which I'm not ever going to let you do, but if that happened or there was a serial meeting, it would be the date that meeting took place. Because it always gets out.
But wouldn't the starting
Because
point
if you took action, if you let's say that you voted to, you held a secret meeting and you voted to approve a contract for surveillance equipment with Flock, and then we spent the money and we did it. This council did. That's the money is always public because it shows up in the warrants. Someone will see, hey, we just gave Flock, $1 million. What is that for? So there are ways to find out, and people watch that. I don't know if I don't think there's anything in the Brown Act that tolls that 90 days.
So it's not knowledge of, it's the actual time of the violation.
Right. I believe that's correct. Another possible consequence is a civil action. Anybody, an interested person, can challenge an action of the legislative body in court based upon the Brown Act. Usually, again, that's citizens or newspapers, media. Courts tend to be very strict, but the standard is substantial compliance. So if we substantially complied with the act, we're probably okay. We don't have to have absolute compliance. It's basically good faith, substantial compliance. The person has to show that the alleged violation resulted in prejudice. So if the action didn't hurt them or hurt the public in any way, probably wouldn't amount to much of anything. For example, if an item not on the agenda is discussed, a resident is prejudiced if they had something to say about the matter but didn't attend. However, if 50 people all stand up and say the same thing as the plaintiff, then there's no prejudice. There's also criminal penalty provisions in the Brown Act. If the body takes action during a meeting with the intent to deprive the public of information, that's potentially a misdemeanor. I'm not aware of anybody who's ever been convicted of that. lots of accusations, but I'm not aware of any conviction. I could be wrong. There might be one out there somewhere, but I'm not aware of it. As I said, that's very rare, but some district attorneys have been willing to allege the violations a lot more frequently than they used to in the past. They used to get alleged and the DA would say, yeah, I'm not touching that, because it typically was, very political and they don't like to get involved in local agency stuff. If you want to read more about the Brown Act, there is a California League of Cities website that talks extensively about it. You can read about it there. Let's talk now about the California Public Records Act. So let me step back just for a second, Board Member Brass. Back to your question about a secret meeting. So if there was a secret meeting, that I think would fall under the criminal provisions of the Brown Act, because that would be a clear intent to deprive the public of information. And that would not be a 90-day statute of limitations in that case. You could get prosecuted for that. Forgive me 1 second here. Let me just let my wife know that I'm in a meeting. Okay. Public records are an area that can sometimes be frustrating for staff and for board members, because it can become intrusive, especially with the latest case law that's made it more and more intrusive. So let's talk about that a little bit. So the CPRA, the California Public Records Act, was enacted in 1968. And I'm going to read a little section from the preamble to that law as well, because I think it's important. It says that access to information concerning the conduct of the people's business is a fundamental and necessary right of every person in this state. And in 2004, voters made that principle part of the Constitution of the state. The provision added by Proposition 59 says the people have the right of access to information concerning the conduct of the people's business, and therefore the writings of public officials and agencies shall be open to public scrutiny. Openness in government is essential to the functioning of a democracy. Implicit in the democratic process is the notion that government should be accountable for its actions. In order to verify accountability, individuals must have access to government files. Such access permits checks against the arbitrary exercise of official power and secrecy in the political process. So what is a record? Well, it's any writing containing information relating to the conduct of the public's business prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristic. So writing can be misleading. A writing can be something that's physically written, handwritten, typewritten, recorded, video recorded, an email, a text message, anything that we can access from software. So all of the reports that all of our government software produces, even though they're not in a physical form, but they can be generated by pressing a few keyboard buttons, those are public records. It's virtually any kind of record you can imagine. Let's go to the next slide. So staff receives PR requests from a number of different sources. So they can come online, they can be by email, telephone, in person, they can be written on the back of an envelope and handed to somebody. So the requests are a lot. We get a lot of them. In fact, I was looking at it earlier today in connection with something else. We've gotten nearly 700 requests already this year from the public. We have a platform called Next Request that's online that all of you have access to if you'd like to look at that, where you can look at all of the Public Records Act requests that we've received. So people will go there and they will make a request. They can make a request anonymously. It doesn't matter. They can make a request with a fake name. It doesn't matter. They can, as long as it's a request, it has to be responded to and records have to be provided with some exceptions. Every department in the city has what we call a PRA coordinator. That person is responsible for processing Public Records Act requests that relate to that particular department. Typically what they'll do is they'll do an email search, which is a search of all email from all city staff. Every email that every employee of the city writes or sends or receives is saved in a system that we can access and do a search in. They have to look for also physical records. We still have physical records. Not everything is electronic. So there are boxes of records in the basement. We have boxes of records in offsite storage units, hundreds of thousands of pages of stuff that we have to dig through to find the documents that someone asked for. PRA coordinator is also responsible for communicating with the requester. So the person asking for the record, they have to be kept informed. Let's go to the next page. So I wanted to show you, give you an example of what it looks like when we get a Public Records Act request on Next Request. These are kind of how they come in. Increasing amounts of data are being stored, accessed, and shared on both public and private computer drives. Wading through large amounts of data, determining disclosability and exemptions, all while respecting privacy rights and responding within reasonable timelines are things that we have to do. Failing to do that, to respond to the requesters, to provide records that they ask for, can result in litigation. That's expensive, and if we lose, we get to pay the attorney fees for the other side. Go to the next slide. So there's at least one staff member, sometimes more than that, in every department who processes these requests, and they're responsible for handling all of them. Sometimes some departments, for example, the police department, have very large amounts of requests. There are literally every year hundreds of requests for police department records. It's kind of an older statistic here. 223 PD requests for 2019 out of the total 692 to date. Our requests have gone up. We have over 1,200 a year. Last year there was over 1,200 requests. We're on our way to about that this year. Next page. Who can request a record? Literally anyone. Anybody in the world, it doesn't matter. The Public Records Act does not make any distinction between a citizen of Vallejo, citizen of the state of California, citizen of any other city in California, citizen of another state, citizen of another country. It just says person. Can we ask what they want it for? Sure, but they don't have to tell us. They can say, because I want it. That's a valid reason. Everybody's entitled to the same access, whether or not they're anonymous or they're actually adversarial to the city. So an attorney representing a plaintiff in a case against the city can file a Public Records Act request, and we have to provide those records if they're disclosable. And that happens with some frequency. We have to help the requesters with the form of the request. We have to help them with the content of the request if they ask us. We have to respond in a timely manner. We also have to assist the requester in figuring out what they want to ask for. Let's go to the next page. So this is a newer case that really affects all of you. You're not affected so much by the fact that we get requests from the public and we have to provide documents, but this actually affects you. So in the city of San Jose case, there was in San Jose, San Pedro Square, there was a open market there. A fellow named Ted Smith filed a writ of mandate asking the court to compel the city to fulfill its Public Records Act obligations. And what did he ask for? He asked for essentially emails on private email accounts of city council members. City councils or the city said, no, we're not going to supply those because those are on private email accounts. We don't have any control over those, and so we don't have to provide them. So what the court said was, a city employee's writings about public business are not excluded from disclosure just because they've been sent, received, or stored on a personal device or account. So the holding in this case was that city employee private email accounts are subject to the Brown Act if there are emails there that discuss city business. And employees includes elected officials and appointed officials, so that would include you. And this, by the way, is a California Supreme Court case. So this is precedent setting. It means we have to comply with it. And we get requests for private emails all the time. And that could happen to you. So let's expand that a little bit. There are some federal court cases that have said under the federal version of the Public Records Act called FOIA, that private text messages dealing with government business are also subject to being disclosed. And we get those requests all the time. When somebody makes a request, for example, for emails of a city council member, they also always ask for text messages. And those are more difficult because it's more difficult to search for them. It's more difficult to find them. And it's also, a lot of people delete those. Are you supposed to do that? No. If it's a public record, you have to save it forever. Am I going to be able to know whether you deleted your text message or not? No. There's no way I would know that. Am I going to be able to know whether you deleted emails on your private email? No, there's no way I would know that. But what we do when we get this kind of request for emails on a private email account or text messages, we require you to sign an affidavit that says you've done the search, that you haven't found anything, and you swear under penalty of perjury under the laws of the state of California that it's true. And the court said in the San Jose case that we're entitled to rely upon that. So if it's found out later, for example, if we get sued and your records are subpoenaed and you turn them over and they're there, that does create a problem. But then we pull that affidavit out and say, hey, he told us no. And then it would be your problem. So it doesn't happen often, but it has happened where boards of commission members have been asked to search private emails and private text messages. I want you to be aware of that. That is probably the biggest piece of this tonight, this discussion on the Public Records Act that's going to have effect on you. Let me extend that a little bit further. There is also new federal case law that says that your social media accounts are subject to the Public Records Act. So if you have a Facebook account, for example, and you have any discussion on there about city business. Let's say that you have a Facebook account and some member of the public says, hey, board member Smith, I know you're on the surveillance advisory board, and I don't like the fact that we have traffic cameras all over the city and that they're taking photographs of my license plate every time I drive through the intersection, and you respond to that. That now becomes a record that's subject to disclosure. There's also case law out there, the federal case law again, that says that you cannot block people from accessing your social media accounts if you discuss the business there related to your activities on their surveillance advisory board. So I say that just to make you aware of that so that you're careful when you use social media accounts. I personally don't ever talk about anything with the city of Vallejo on my one social media account. I have a Facebook account that I use to keep up with family and friends who are in back east and in Europe. So I avoid talking about anything to do with the city. Even I don't even say that I'm employed here. So I would advise you to do that, or if you want to, because you are an appointed member of a public board and body, if you wanted to have a social media account where you talked about issues related to the surveillance advisory board, then I would have a separate one from your personal one where that's all you do. And again, you also have to be careful in doing that about violating the Brown Act, because if one of you has a social media account and the others look at it, and you've said, for example, what you feel about an issue, now you've telegraphed that to other members of the body, and they could say something on the social media account. Well, I agree with you. Let's say 4 people agree. Now you've violated the Brown Act. So that's what I meant earlier when I said this stuff can be really complicated. You've got to be on your toes all the time about it. Let's talk about Getz versus County of El Dorado, another case. So there's a provision in the California Public Records Act that says that public agencies can refuse to respond to a Public Records Act request if it's overburdensome. We have generally, before Getz, this particular case, we've considered it to be overburdensome if it was over, say, 10 or 15,000 emails. Even 10 or 15,000 emails is pretty burdensome. The reason we say that is because somebody has to sit down and go through every single one of those emails to make sure there's not anything in there that is attorney-client privileged, that violates somebody's privacy rights, or falls under one of the other narrow exceptions that are set forth in the Public Records Act. I don't know if any of you have ever sat down and reviewed tens of thousands of emails at one time. It takes hours and hours and hours to do. I have. I can tell you it's not an easy task. It's tedious, and can really consumes a lot of time. Well, in the Getz case, someone asked for records. There were over 47,000 emails in the records that were requested. The city in that particular case, or the county of El Dorado rather, said, hey, that's overburdensome. It's going to take our staff 50 hours to review all of that. So someone's going to have to sit down for more than a week and go through 47,000 emails. And their position was, we have better things for our employees to do. The court said, gee, that's too bad, but you have to do it. 47,000 emails is not overburdensome. I could tell you here that if we had to review 47,000 emails, that it would take, it would probably take more than 50 hours. I'm surprised that they thought they could do it in 50 hours. It depends on the department. With PD, for example, we've gotten requests for tens of thousands of emails. That takes a really long time because there we are dealing with a lot of times officer privacy rights, employee privacy rights, or attorney-client privilege things that we have to deal with. So really tough, but the court said, too bad, you've got to do it. So we have in the city of Vallejo, in the city attorney's office, we have an attorney whose only job is to process Public Records Act requests. So she spends her days reading emails and going through and deciding what can go and what can't go. And I don't say this to complain to you, because I personally believe in the Public Records Act. I think the public has a right to those records, but I don't think people understand the amount of work that goes into getting the records prepared and getting them processed and getting them distributed to the public. It's a lot. Let's go to the next slide. I'm not going to talk about that too much. This is talking really about the deliberative process privilege. So behind the scenes, a lot of times staff will work on documents, agreements, things like that. And there'll be several iterations of it that go around. Well, this particular court decision stands for the principle of what's called the deliberative process privilege, which means that we get to deliberate about how our final product is going to look, and we don't have to tell people what all of our deliberations were. So if I write a contract and I send it to the department that asked for it, and they come back and they say, well, no, I want these changes, and they send me back red lines, I make the changes, or I add my own red lines and send it back, and we go back and forth 3 or 4 times, those drafts don't get disclosed. That's deliberative process. The only thing that gets disclosed is the final product. Let's go to the next slide. So what's the city's responsibilities? Well, unless the requested material, the search is overbroad or it's unduly burdensome, we're obligated to disclose all records that we can locate with reasonable effort. Doesn't require us to undertake extraordinary, extensive, or intrusive searches. In other words, we don't have to look for a needle in the haystack necessarily. But it has to be an effort that's reasonably calculated to locate responsive documents. There's no duty for us to create what's called a record or a privilege log. So privilege log is basically it's a written document that discloses the privileged items or gives a description of a privileged item and provides it to a requester. We don't have to do that. The cost for producing records is free, especially if they're electronic, with one exception. If we have to make paper copies, we can charge for that, but it's not a lot. I think it's 20 cents a page now. We can charge for making redactions on videos. So there are some recent laws that were passed that require certain body-worn camera footage for police departments to be disclosed to the public. And that's body-worn camera footage that relates to an officer-involved shooting or an incident that involved great bodily injury to a member of the public. Those videos now have to be disclosed. However, the law also requires that some redactions be made to those videos before we can disclose them, and it's mandatory. We have to redact the identities of witnesses. So that means if a witness's face appears there, we have to redact that person's face. If the license plate number of a car that's not a city vehicle is there, we have to redact that. And I can tell you that that's not easy. We hire a special firm to make those redactions. It's very expensive, and it takes a very long time to do. There are some exemptions, again, to the Public Records Act. Things that are privileged, attorney-client privilege, don't have to be disclosed. Attorney work product does not have to be disclosed. Privilege covers attorney bills and retainer agreements with outside counsel. There's a limitation on disclosing code enforcement records. The deliberative process privilege we've talked about. Drafts, notes, other things that we don't keep in ordinary course of business don't have to be disclosed. So there are exceptions. Let's go to the next slide. I think we're going to skip that. I don't think it's important for you. I'm only gonna talk a little bit about this, but only as it relates to your private emails and social media. What's a reasonable effort? When we ask you to make the search, we take your word for it, all right? And again, we ask you to sign an affidavit under penalty of perjury that says you've done it, and we take your word for it. If you decide to not do the search and you decide to be untruthful on that affidavit, that could become a problem for you later, right? Um, I'm not saying that anybody's ever done that. I don't know, and I don't care to know. But those kinds of things have a tendency to come out in litigation. If somebody subpoenas records, a lot of people don't realize that your cell phone in litigation can actually be subpoenaed by an adverse attorney. Your computer hard drive can be subpoenaed, and they can go through there have a forensic expert go through that hard drive and find out what you've deleted. So there are a lot of things that can happen. So I always advise people when we ask you to do an email search that you actually do it, because it can be found out. If there's a lot of smart lawyers out there. If somebody really wants to get the information, they'll get it sooner or later. So just be careful when you do that, and we're happy to help you. We won't do the search for you, but we'll help you to the extent that we can. Personally, I don't want to look at your personal email. I don't want to dig through that. I don't think that's right. But we will help you as best we can to get you through it if somebody makes a request for the information. Let's go to the next slide. Yeah. So the city has admin rules about public records, about maintaining them, maintaining the security of those records. They generally only apply to staff, but in this instance, I want you to be aware that there are rules out there. We have a retention schedule for documents. It's generally 2 years for most documents, but some are required to be kept longer than that. And records cannot be destroyed in the city of Vallejo without the approval of both the city clerk and the city attorney's office. So in order to destroy records, a department has to submit a request to us with a description of the records that's a big enough description that we can actually tell what it is before we will actually approve it. Let's go to the next slide, please. So one thing that you might consider doing is opening a separate email account just for SAB business. That way you don't mix it with your personal email, and it becomes really simple then if we ask you to do a search to go and look and see what's there, so that you're not digging through tens of thousands of emails at one time. It's easy to do on Google, or there are other services out there. Proton, I think, is another one. But there are several email accounts that you can open, and I would suggest that you do that. And I would limit the amount of emails. If it were me, I would limit the amount of email that I do, so that I don't have to conduct extensive searches if somebody asks for it. Same thing with texts. That's become a really convenient way for people to communicate in this day and age. But my recommendation would be to limit the amount of text messages that you use if you're talking about SAB business. So what happens if you don't, and we've already kind of talked about this, if you fail to respond to a request, if we ask you to search your personal email and you decide not to do it, that can result in a Public Records Act lawsuit. and you can be dragged into court in that. That's where an attorney on the other side can drag your hard drive in or subpoena Google for all of your emails or whatever, and find out what it is you didn't disclose. There are also attorney fee provisions in the Brown Act that I mentioned earlier. If we as a city get sued based on a Brown Act, or I'm sorry, on a Public Records Act violation, there are attorney fees provisions. If the requester wins the lawsuit, we get to pay their attorney fees. If we win, they don't have to pay our attorney fees. We still pay for the attorneys that we hire. So just keep that in mind. Next slide. Let's go to conflict. No, go ahead. Let's go to conflict of interest. So I'm going to really gloss over this because this isn't going to apply to you very much. It does to an extent. But there's something out there called the Political Reform Act. Basically, the Political Reform Act was enacted after Watergate in 1974. And I'm old enough to have lived through that and remember it. It was a big scandal. The initiative was championed by then Secretary of State Jerry Brown. We recognize him. He was Secretary of State when that was adopted, as well as two entities called the People's Lobby and Common Cause. California was the first state in the Union to adopt such an act. It was intended to end political corruption by reducing the amount of money spent in elections and by eliminating secret or anonymous contributions. Next slide. Covers a wide range of requirements: campaign finance, which isn't going to apply to you, lobbyist registration reporting, political mass mailings at public expense, post-governmental employment, gifts and honoraria, financial conflicts of interest by public officials. It created something called the Fair Political Practices Commission, which is a state agency that has the power to interpret and enforce the provisions of the Political Reform Act. They act as an advisory agency and an enforcement agency. So they can come after you if they think that you have violated the Political Reform Act. Go to the next slide. So the basic prohibition is that you can't vote or participate if you have a financial interest in a matter. Financial interest is broad. It doesn't just mean ownership in an entity. It can mean a lot of different things. So let's take a look at what that is. Let's go to the next slide. If you, as a public official, and that's what all of you are, you're public officials, will benefit financially in a way that the general public will not benefit, you have a financial interest. So let's say Flock comes in and they're going to sell us a red light camera system, red light enforcement camera system, something we recently talked about. And let's say that one of you owns $1 million of stock in Flock. And if they sell us this new red light camera technology, we'll be the first. We're going to test it, and it's going to open up the door for them to be able to sell this all over the state of California and make billions of dollars. That's potentially a financial conflict, and something that I hope you would ask us about before you voted. Even though you're advisory, you have influence on the outcome of it because you're voting to recommend it to the city council to approve. You have a financial decision or a financial interest in a decision if it's reasonably foreseeable that the decision will have a material financial effect distinguishable from its effect on the public generally, on the official, a member of his or her immediate family, or any of the enumerated economic interests. So it's not just you. If you have a family member in that same scenario that owns a million shares in Flock, and those shares are going to increase because of a decision you make, that is a direct economic interest that you have to be aware of. Let's go to the next page. I'm not going to talk about this too much. What I want to have you take out of this is if you think for any reason that you have a conflict of any kind, financial or otherwise, that you bring that question to me or to Naveed and let us take a look at it and advise you as to whether or not there is a conflict. If we think there's a conflict, there's still a way to deal with that to potentially allow you to vote, or if 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 the line is too dim for me to determine whether you have a conflict, in those cases, what I like to do is to make a request of the Fair Political Practices Commission that they provide written advice, which then provides immunity to you. So if the same scenario, million shares in flock, we're going to vote on it. If we ask FPPC to issue a letter on that, an advice letter, and they come back and say, hey, no problem, doesn't matter. It's not a big enough financial interest. You can vote on the matter, and you do. Now you can't be prosecuted. You're immune. That wouldn't happen, by the way. There's no way they're going to say that's not a financial conflict. So we're going to go ahead and skip past all of this, Manny. Keep going. Go to step 3. Stop there for a second. So what's an economic interest? I wanted to point these out to you. Real estate, I'm not too worried about that because you guys aren't ever going to be doing anything with real. Well, I'm going to take that back. So let's go back to this flock example. Let's say that you owned the real estate where Flock's factory is, where they manufacture these red light camera systems. That could be a conflict in this instance. So yes, it could be. So if you're a landlord of an entity that comes here and asks you to approve or to recommend surveillance equipment to the city council, that potentially is a conflict because the city giving them a contract means that they can pay you, right? As a landlord, they can pay the rent. Your personal finances or the personal finances of your spouse, domestic partner, or dependent children, those could all potentially be an economic interest. Sources of income can be an economic interest. If you're an employee of Flock and you vote on a contract with Flock, that is potentially a significant economic interest and a conflict of interest for you. I do want to talk about gifts as well. If Flock says, hey, we're going to give you tickets to the Super Bowl, no strings attached. That's what they always say, no strings attached. And hopefully Flock's not listening. I don't mean that you're actually going to do this. It's just an example. We're going to give all of you tickets to the Super Bowl because we really like you. No strings attached. Well, Super Bowl tickets, last time I checked, are in the thousands of dollars, right? That's a gift. You have to report that if you get it. So all of you should have, or you will, fill out something called the Form 700. That's a document that's required by the FPPC and by the city for all of its elected and appointed officials and a lot of its employees. I have to fill one out. In there is where you would disclose gifts like that. If you received a gift from Flock, you would disclose it there. And so the public would be able to see that. The whole world would be able to see that. So you want to be careful about accepting gifts with a value of $590 or more within 12 months before a decision on an item is made. So if Flock gives you a gift of Super Bowl tickets, say it's $1,000, and you have something come before you 12 months from the date that gift was made regarding Flock, then you should recuse yourself from voting on that particular item. And again, I just want you to be aware of this. You don't have to get into all the details of it. I want you to be aware that there are potential conflicts out there. And if any of you ever believe that you have a conflict of any kind, no matter how small, please ask us about it. And we're very good at getting back to you and dealing with those. If you have a business investment that relates to an entity that appears before you that you're going to vote on, that potentially can be an issue. We talked about employment. If you're an employee of a company that sells surveillance equipment that's coming before you for a decision, that would be an issue. And what do you do if that happens? You disclose it and you recuse. So you don't participate in the vote. And recuse basically means that you step down and walk out of the room while the rest of the board deliberates over the item. Next slide. I'm not going to get into all this detail. You don't need that. Next slide. Same thing. Next slide. Yeah, let's go to the next slide. There are exceptions. I don't want you to think about that. Let me deal with that. If you think you have a financial interest of any kind, just ask me about it and let me help you. Next slide. Yeah, and this is why I want you to ask me, because the tests for determining whether it's material or foreseeable are really, really complex, right? And it's also very fact dependent. And I know the questions to ask you to get the facts that I need to make the determination, and you might not know that. Let's go to the next slide. This is what I was talking about earlier. You can get advice from the FPPC. If you need that advice, let us help you do that. We know how to write the letters and get it. You can also call them for informal advice that does not give you the immunity that we were talking about earlier. But if you have a question, you can call them at this number that's on the screen there and in your packet and ask them to give you advice. And sometimes that's helpful because, you think you might have an issue, but it maybe not. And, it seems kind of distant. You can call them and just ask. And they're pretty good about responding, and they're pretty good about giving advice. And they're actually really easy to deal with. I've dealt with them a number of times over the years. They really do want to help. So don't worry about calling them up and asking for advice if you need it. Or if you think that you need formal written advice, let us know and we'll help you write the letter to them. Let's go to the next page. Recusal and declaring the conflict is what I just mentioned a second ago. If you do think that you have a financial conflict of interest, then you need to recuse and not participate in whatever the decision is where you have the conflict. That means you step down from the dais and go outside, and then we'll come get you when we're done with the item. There are also a couple of other considerations on conflicts of interest. There's a section of the California Government Code called Section 1090, where you can't have an interest in a contract that comes before a body. And if you do, it's potentially criminal if you vote to approve it and you're getting a benefit from that. There are also common law conflicts of interest. So whatever is not covered in the Fair Political Practices or Political Reform Act may fall under common law conflicts of interest. So again, if you think that you have one, please ask us, right? Either myself or Veronica Nebb, the city attorney, ask us. We don't want you to get in trouble. And so we'll do everything that we can to help you. Any questions about any of the stuff we've talked about so far? Okay. Let's talk about the powers and duties of the Surveillance Advisory Board. These powers and duties are found in the Vallejo Municipal Code in chapters 2.26 and 2.27. And if you want copies of those, I'm happy to provide them. They're also available online on the city's website. Chapter 2.26 applies to all boards and commissions within the city. 2.27 applies specifically to the Surveillance Advisory Board. No, back up one slide, please, Manny. Yeah. Yes, there is an attendance policy, and that's in chapter 2.26. The city council expects board members to attend meetings. If you miss a meeting, it's advisable that you seek an excused absence from the chair and staff at least 24 hours before the date and time of the meeting. You're allowed up to 3 excused absences in a 12-month period. After the third absence, you'll get a letter from the city clerk warning that if you have a fourth absence, you can be removed from the board. Yes, sir. Yes, Chairman. Correct. Well, you get 2 unexcused. Yeah, so there are 3 excused. Yeah, it should say 3 excused. That's a mistake. You're right. And two unexcused in a 12-month period. So after the 3 excused, you get the letter from the clerk warning you that if you miss one more, you can be removed. Same thing, after 2 unexcused absences, you'll get a letter from the clerk saying that you can be removed if you have one more unexcused absence. Let's go to the next slide. You're a 7-member board, so 4 members constitute a quorum. A majority of members present can take action. So if there are only 4 of you, a majority can still take action. Let's say only 3 of you vote to approve an item. It's still approved even with 3 votes, even though it would require 4 if there were 7 of you here. You have regular meetings on the 3rd Thursday of every other month. Sorry, it says every month here. No, it says every other month. Yeah, it does. 3rd Thursday of every other month, beginning with the month of adoption. And I don't remember that when that was, but this tonight was one of your regular meetings. City staff can cancel, actually Naveed can cancel a regular meeting if there are no items that require your attention. That has to be done, though, 72 hours in advance of the meeting. There can be an emergency cancellation if something happens, if there's a city emergency. Other cancellations require the written consent of the chair and the vice chair. So if staff decides for some reason we've already posted an agenda and we need to cancel a meeting because no staff's going to be able to attend the meeting, we'd have to get approval for that from the chair and the vice chair. Next slide. All boards and commissions in the city of Vallejo use Rosenberg's Rules of Order as the rules of order and procedure for conducting business at public meetings. I'm not going to get into the details of that. I've got some handouts I'll give you before we end here about Rosenberg's that are really pretty simple. And Rosenberg's is actually very simple. So I've got a cheat sheet and a more extensive explanation of it if you want further information about it. And if the board as a whole wants training on Rosenberg's, we can do that at a later meeting if you desire. The board, if a majority desires to do so, can also propose additional or alternative rules of order to the city council. Let's say that you like Robert's Rules of Order better. If you want to do that, then you could make that proposal to the city council and see if they go along with it. If they do, then you can use those rules. If not, you have to keep using Rosenberg's. You can also adopt a work plan, which has to be aligned with the goals and priorities of the city council. We've talked about that over the years, but we haven't actually adopted one yet. But you can do that. It's not required. You can do it if you choose to. Agendizing matters. This does come up from time to time. So the city has a 2-step process for board members to agendize items. So there's a process for doing that, And what you'd have to consider are the following things. You have to consider whether or not it's within the subject matter jurisdiction of the board. It has to be agendized for discussion by the board as to whether a majority of the board wants to put it on the agenda before it's actually deliberated on the content of the item itself. So a majority has to approve placing it on the agenda at a future meeting. And then you get to actually consider the item at that second meeting. That's what we call it, a two-step process. Criteria for agendizing: is it within your subject matter jurisdiction? Is it part of your approved work plan if you have one? Is there sufficient staff available to be able to write the staff report and do the research that's often required to bring an item before you? Staff can agendize items without going through the two-step process. I know that seems unfair, but there are certain things that are in the chapter 2.27 that we have to bring to you. For example, if the police department desires to purchase new surveillance equipment, that has to come to you. And so we don't have to go through a two-step process for that. We just put that on the agenda. Yes, sir. Usage of existing equipment, yeah, a new usage, yes. If it's a new use, something that we haven't done before, yes, we should bring that to you. So the city council has also codified some rules of decorum for its boards and commissions. And you'll find those in chapter 2.26, 0.140 of the municipal code. And here they're listed here. So you're to act fairly and respectfully when considering items, make decisions based on the merits of the issues, honor the city's legal obligation, honor the public's expectation of fairness and impartiality to all people and perspectives, exhibit compassion, care about the needs of the public, officials, and staff, treat board members, staff, and the public with courtesy even when disagreeing, discharge your role in a responsible manner, adhere to the attendance policy, refrain from taking action that appears to compromise independent judgment, do not use information acquired in the member's public position for personal advantage, do not represent a third party's interest to the city, act with integrity and remain truthful to fellow members, the public, and others. Be prepared to make unpopular decisions to further the public's interest. Next slide. Remember that you serve the entire community and be a keeper of the public's trust. Collaborate with city staff and with each other, recognizing that staff and members are on the same team. Be mindful of and promote the city's interest as set forth in the city council's adopted goals, the general plan, resolutions, and ordinances. Place the public's benefit above your own and above those of special interest groups. If you're speaking on behalf of the board before the city council, strive to fairly represent the stance and views of the entire board and not just your own. The failure to adhere to any of the rules of decorum are potential grounds for removal at the request of any city council member and the affirmative vote of at least 5 council members. So you do have a chair and vice chair. So let's talk about those roles. So the chair's role, in collaboration with the secretary, which is Naveed, schedule dates and times for meetings, ensure the creation of agendas and that the same are duly posted, officiate and conduct meetings, serve as parliamentarian, which means you make determinations under Rosenberg's if they come up. Provide leadership and ensure that members are aware of their obligations. Ensure that the board complies with its responsibilities. The vice chair steps into the exact same roles in the absence of the chair. Secretary's role is to attend all meetings and in collaboration with the chairperson, vice chair, and city attorney, establish agendas, maintain board records, and provide support to the board. So if you have questions about your roles or duties, or you want the board to consider certain things, your first point of contact is always going to be Naveed. Role of the city attorney. The city attorney's job is to assign an attorney to provide legal advice to the board. I am that lawyer. We review all the agenda items on the board's behalf to ensure compliance with applicable laws like the Brown Act. We ensure that agendas do not exceed the subject matter jurisdiction of the board, and we attend all your regular and special meetings. We have, by the way, had one agenda that did not comply with the Brown Act. Some of you might remember, and we canceled that meeting and rescheduled it. An address or where the meeting was held was inadvertently left off that agenda, and so we had to reschedule that because it would be a Brown Act violation to continue. Let's talk about the power and authority of the board. And this all comes directly from the ordinance itself, which you're more than welcome to read at 2.27.030 in the city's municipal code. You're to advise the city and the city council concerning surveillance technology to protect the safety, privacy, and civil rights of Vallejo residents. What is surveillance technology? It's defined in the ordinance. It's the systematic observation for law enforcement purposes of places, persons, or things by visual, oral, electronic, photographic, or other means. So pretty broad. Let's go to the next slide. Again, powers and authorities. Yes, sir. If we have them and we're using them for law enforcement purposes, yeah, it could be, yeah. If they're just, if they're just cameras that citizens are putting up on their property, no, we don't have any authority over that. We have cameras, for example, in the parking lot at City Hall. There are cameras at some of the entrances, primarily for security purposes. And I think we did talk to you about those some time back. Yeah. Yeah. Sure. So if we were absolutely, it is if it's for law enforcement. So let's say the police department wanted to put up CCTV cameras downtown to monitor all the sidewalks. Yeah, we'd have to come to you with that. Because that implicates privacy interests of the public. Back to your powers and authorities. You have the power to conduct meetings to collect public input about the use of surveillance technology. You have the ability to seek the advice and testimony of experts, if you so desire, on surveillance technology. You can submit written recommendations, findings, and reports to city staff and the city council about the acquisition, deployment, and policy concerning surveillance technology.
City attorney.
Yes, sir.
Can you give like a little bit of clarity or maybe an example of the first one, the conduct meetings to collect public input about the use of surveillance
Sure.
technology?
So we do that on a fairly regular basis. So let's take the red light camera system that we talked about. Whenever you hold a public meeting, that is the public's opportunity to come here and talk about that particular item that's on the agenda. And I don't remember if we had a member of the public talk about the red light cameras, but they can. And that's one of the reasons that we provide an agenda, we post it, and we put it online so that the public is aware that we're going to have a meeting, that we're going to talk about that particular item that night. Um, and they get, they can come in and give their input. That's the whole point, really, of the Surveillance Advisory Board's existence, is to be able to allow the public to do that.
Thank you. So that's not taking into account, like, this is specifically like the meetings that we're already
Yes.
having, not we're going to create a new meeting and
No,
get input. Okay, cool.
Yeah.
Thank you.
if you wanted, to do that, we had another board and commission that wanted to go and have a town hall meeting. You potentially could do that, but you'd have to go ask city council if that was okay, because there is an added expense of staff having to find a venue, staff it, and do all those kinds of things. And then there are also ways that it needs to be done because, again, we don't want to violate the Brown Act. Normally, a majority of you would probably want to attend a function like that. So we would post it as, again, it would just be a meeting anyway. So, because we'd prepare an agenda and post it, which we already do. You're welcome.
I have a similar question.
Sure.
For the second item there, would the same thing be true about seeking the advice of experts in terms of asking city council ahead of time?
That actually is already embedded in the ordinance itself where you can do that. It doesn't allow you to incur an expense for it, right? If you wanted to incur an expense to hire an expert, then that would have to go to council. But if there were an expert that was willing to come before you and provide advice without a charge, that would not be a problem.
To the chair, would we be asking for advice or information?
It would normally be, it could be both, potentially.
And could that not also be done individually? Each board member seeking their own personal expert?
Could you go out and ask an expert yourself? Of course. Yeah, but you wouldn't, that's where you need to be careful. You can't go get that advice and then start calling up other board members and say, hey, this guy told me X, and, I think we should do it. If you wanted to do that, if you went out and sought some advice from someone and you liked what the person had to say and you wanted the rest of the board to hear it, then you'd ask Naveed to agendize that and invite the person to a meeting. Let's go to the next slide. Nope, back one. Sorry, Naveed. So sometimes the city council will ask you to review things. That's happened a time or two. Also, city staff routinely ask you to review requests concerning surveillance advisory equipment. And typically that comes from the police department. That's why you have representatives from the department assigned to you so that they can bring items and that you can ask questions about things from them. The ordinance requires that you provide a recommendation to the person requesting a recommendation within 45 days of submission. Otherwise, after that, if you don't provide a recommendation, then the requester is free to go forward acquiring, borrowing, and deploying whatever the surveillance technology is they're asking about. Whether it's deployed or not, the board can provide advice at any time concerning the use of any surveillance technology the city owns. So this gets back to what Chair Lee was asking about a little earlier about if there was a new use of technology. Yeah, you could, if you found out about that, then that would be something that you would bring up to us so that we could get it on an agenda and bring it to you. We actually would have a duty, in my opinion, if the police department decided to go out and utilize some existing technology in a way they're not utilizing it right now. I think that we would have an affirmative duty to bring that to you. So there are some instances where the city can go out and acquire, borrow, deploy surveillance technology without your input. And that would be in an emergency. And the ordinance doesn't define an emergency, but I would look at it as somebody's life and limb being in danger. And the use of some surveillance technology would save that person or would have a chance of saving that person. Then it could be used without getting a recommendation from the board. However, if that was done, let's say the police department did that with some piece of surveillance technology, they would have to come back to you. They would have to bring it to you no later than 30 days after they used it to get your input on it. You also have the power to draft and recommend model legislation concerning surveillance technology for consideration by the city council. So if you thought that it's necessary to have an ordinance concerning the use of some type of technology, surveillance technology, you could actually draft that and recommend it to the council. You can request, receive, and analyze information about any city department's acquisition or policies related to surveillance technology. We do that fairly routinely here. The police department provides you reports about its use of its technology just about every meeting. Let's go to the next slide, please. If the information you ask for happens to be protected by the attorney-client privilege, or it's subject to laws that protect employee privacy or things like that, then we will not provide it to you. But we'll tell you why. We're not just going to say no, you can't have it. We'll tell you it's it's privileged. Sorry, we can't provide that to you, or there's a privacy right that's impacted. Okay, so we got through it all. And if you have any questions, this is my contact information. Email is probably best. If for some reason you don't hear from me in a time period where you think you should have heard from me, either reach out to me by phone or reach out to Naveed, because I do have lots of emails and sometimes stuff gets buried under 50 or so emails and I miss them. But I try not to let that happen. Anybody have any other questions? Sure, you can. Microphone, please. So everybody else can hear.
Hi, I'm Ron Tesno. I live in the Heritage District. Thank you for the presentation. It was really informative. I just had a question. Is the Brown Act federal or is that state?
It's a state law.
It's a state law.
Yes.
And then how many city council members do we actually have?
7.
7. Okay. So 5 out of 7 need to vote positively for
5,
sort of,
4.
dismissal.
4 is a quorum.
Well, that one thing said 5.
5
they're
to
removing
remove, that would be to remove a member of a board or commission.
Okay.
It's not just this commission, it's any board or commission in the city.
Wonderful. Thank you for your consideration.
Of course, you're welcome.
Yeah, very quickly, adopting a work plan, there was a note in there about it having to be aligned with the city council. Who
Right.
makes that determination?
So the city council publishes its goals, right? They do that once a year. And so the work plan has to not be in conflict with that. That's what I think being aligned means. Because the city council goals wouldn't necessarily mention the surveillance advisory board. They could, but if they don't, then you just wouldn't want to be in conflict with anything that they have there.
So we would make the determination. It doesn't go to city council to determine
Right.
whether it's consistent.
Right. We'd advise you on whether we think it's aligns with that.
What is the example of an existing one?
You have certain things you want to do throughout the year. You would talk about what those are and how you're going to get there.
I can jump in that for quickly. So we had talked about creating, one of the items in the work plan could be, we had talked about it in the past, is to create a one pager for each technology that you have reviewed. So we have a clear sign off of each technology. So that would be an example of a work plan.
It's a planning document. It's something that, ends up in a binder like this and depending on how long it is. And that's something that you could refer back to during the year to see if you're on track with what you wanted to accomplish that year.
How do we get emails for SAB? Is that a low lift?
No, we do not issue emails other than planning commission and city council. So SAB members would have to get their own emails. So get a Gmail with mike.sab@gmail.com. And that's what Randy was talking about earlier. You keep your SAB emails separate.
Got it. Okay, thanks.
You're welcome. And for the board, we have a generic email, sab@cityofvallejo.net. So you can send emails to that. And then actually members of the public can send emails to that to email box as well, and I can forward them on to individual members.
It's just one request for you, Naveed. Could all the board members at the next meeting have copy of the code printed out?
Yeah.
Okay, thank you.
Yeah, absolutely.
Yeah, absolutely. Not a problem.
Oh, while I'm thinking about it, let me give you this Rosenberg's
Oh,
stuff.
yeah, thank you. And thanks for your presentation, Attorney Meisner. Thank you. Okay, great. Good sheet. Thank you.
It's really try to keep it fairly informal, unless there is some kind of dispute over process, then we call that
Formal, yeah.
Because I want you guys to be able to talk about what we're talking about.
Okay.
So
Actually, could I get, I'll just hold on to copies for the board members that aren't
Oh.
present.
yeah, that's fine.
I'll just,
Yeah,
yeah.
that's fine. Thank you.
I'll just hold on.
Just two, right?
It's just two.
Yeah, and I'll
Thank you.
I'll give you.
You're gonna give Russell his?
Yeah.
Okay. He's, no, I don't need to report that. He's just giving him. Right.
I have a quick attendance question. Is it possible and is there a process for appearing remotely?
There is a process, but it requires a reason, right? Like a good reason, you're going to be out of town. So we have allowed that in the past. If it's just for convenience or expediency, the city's policy is that you can't meet remotely.
I can just weigh in, for technical reasons, it could be a challenge.
Oh, it is.
Yeah, especially if you're,
So
different time zones. Stuff like that.
let me tell you what's required. So let's say that you're going to be attending a conference on the East Coast, and you'd still like to attend the board meeting while you're gone. You can do that, but it requires that you post an agenda at the place where you're going to attend, that the place you're going to attend be open to the public, that so you have to allow anybody who wants to come in. And then we have to put on the physical agenda itself that you're appearing remotely, where you're at, and the address. So it's a process and not necessarily easy, and could be disruptive if members of the public from some other jurisdiction who has no idea who we are decide to attend our meeting and, look where you're at and things like that. So just kind of a strange way of doing it, but that's the current status of state law, unfortunately.
Okay. Any Any other questions? Okay, moving on to the information calendar.
We have none tonight because both
Right.
lieutenants and captain were not available. So I'll make the reports available to you in the next month's meeting, 2
Okay.
months worth of data.
Then future agenda items.
Yeah, and we're not gonna take any action on that because most of them were by board member Stewart and he's not here.
Right.
So we can hold
That's right,
off
they're all fine.
until next week, until next month.
Okay, then we can adjourn. Thank you, everyone.
Yep.
Especially Attorney Reiser for the presentation.
Thank you.
Well, we have to, okay, we can just.